information, and we will decide when transcripts of private interviews are going to be released. No one on this side of the aisle has released it other than to ask a question based upon it in a hearing, which is an appropriate use of it.
Reclaiming my time.
We could release it as part of this hearing.
Reclaiming my time, I will observe that some members have released parts of the transcript by being quoted in the media, not for questions here. Does the gentleman from Rhode Island still want time?
I just have a unanimous consent request. I ask unanimous consent that the transcript of this witness be made an official part of this record in its entirety.
I object. Objection is heard.
The gentleman from
I thank the gentleman for yielding. Again, Mr. Chairman, I think this is of tremendous interest to the American people. There's an effort here to sort of characterize this witness's behavior. Much ado has been made of it. We had an 11-hour hearing in which this very same witness has testified. He's now testifying consistently before the American people. There seems to me no good reason, other than a personal preference of some apparently, that this transcript not be released. And I would say to the chairman respectfully, if there is no prohibition, the fact that you would prefer we not is insufficient to persuade me, and I think Mr. Raskin, and we intend to release this transcript unless someone presents us with some rule under our House proceedings or this committee that prevents us from doing it. And we'll give you till 5 o'clock this afternoon to present that. Otherwise, we intend to release the transcript.
Reclaiming my time. I'll simply, I want to associate myself with the remarks of the gentleman from Rhode Island. I would agree with him. I think it would be a public service to release these transcripts. That's why I demanded they be released. There's no good reason not to. And at this point, I think I'll yield back the balance of my time.
The chair wants to respond to the gentleman from Rhode Island. First of all,
yield back the balance of my time.
First of all, there was an agreement in the interview that it was private, confidential, and that it would not be released. So that is not going to take place under this set of circumstances. Secondly, if the gentleman, we're here investigating irregularities conducted in investigations by the FBI. If the gentleman wants to perpetuate that by creating irregularities here and releasing questions so that other potential future witnesses can read the question before they're asked, that is, in my opinion, exactly what many on the gentleman's side of the aisle have been all about, attempting to disrupt this investigation and this hearing process from start to finish.
Reclaiming my time, Mr. Strzok.
Would the gentleman
reclaiming my time?
Chairman, I object.
Mr. Strzok, would you object to the release of the transcript of that hearing?
No, I would not object.
Thank you. I will observe then that the minority, the chairman says that there was an agreement, not on the conduct of that hearing. Minority was not party to that agreement. There may have been an agreement between Mr. Gowdy and Mr. Goodlatte, but at no point were we asked.
It was stated on the record in the hearing.
It was stated as a decision, as a fact, as a fait accompli. We were not asked. We agreed to nothing because we were not asked. And we think that the transcript ought to be released for the reasons stated. And if the witness doesn't object, I don't know why the majority should object. I yield to Mr. Meadows.
If the gentleman will yield in earnest, I will be glad to work with my colleagues on the other side of the aisle about releasing all relevant information. I mean, I think if we're talking about full transparency, let's talk about full transparency in a variety of other things. It's interesting. We want to release one thing, but yet we're somehow allowing Peter Strzok to suggest that there's a whole lot of things that are off the record. But I will work in earnest with my colleagues.
I appreciate the gentleman, and let me simply say that we are not disrupting a legitimate investigation into the investigation. The Republican investigation is intended to and is trying to disrupt the investigation into the Russian interference in our election by the special counsel.
Would the gentleman yield?
Really at stake. I yield back.
The gentleman yields back. All right. So now that the chairman and the ranking member have had ample time to ask questions, and I think that the gentleman from New York has the record, we are going to move, because we have 72 more members who have questions to ask, to strict adherence to the 5-minute rule. And we'll begin by recognizing the gentleman from Wisconsin, Mr. Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Chairman. Let me observe that, there have been all kinds of complaints about leaking transcripts and things like that. One of the reasons we are here today is because there has been a flood of leaks out of the Justice Department about what is going on. It barely a day goes by when you can't pick up the newspaper and find out that it's rumored this and rumored that. And then we have a witness from the FBI that comes up here and says, oh no, we can't talk about that here to the Congress, which has constitutional oversight responsibility because it's against our rules. Well, I hope there'd be a few prosecutions of people out of justice that have been leaking this stuff to the various news media. Now, I want to get to looking at statutes. You look at rules, I've been looking at statutes. And somehow along the line, in the report on the conclusions of the Clinton investigation, the word gross negligence was changed to extremely careless in determining Mrs. Clinton's handling of classified information. Now, gross negligence would mean that it would subject her to criminal liability. Extremely careless would have the opposite effect. It would not. So I'd like to ask you, Mr. Strzok, a couple questions about that. The original May 2nd draft of the statement that Director Comey was making, he characterized Mrs. Clinton's actions as grossly negligent. Is that correct?
That's my recollection, yes.
Yes. And are you aware that gross negligence was changed to extremely careless in the eventual statement?
Yes.
Okay. Now, do you recall at the June 6, 2016 meeting attended by you and Mr. Ribicki, and Ms. Moyer, Mr. Maffa, and Lisa Page to discuss the language of the statute on whether to use grossly negligent or something else in the draft statement? What was discussed at that meeting?
So, sir, I don't remember that specific meeting. There are a variety of meetings with a bunch of people that included discussion of this concern.
Okay, did the alternative phrase extremely careless come up at the meeting?
It did at some point, sir. I don't know if it was during that meeting or at another one. I don't remember that.
Whenever it happened, who brought it up?
My recollection, sir, is that somebody within our Office of General Counsel did. It was one of the attorneys. I don't remember which.
You don't remember who did?
No, it was a legal issue that one of the attorneys brought up.
Okay, now immediately after that meeting, metadata shows that you modified the draft statement on June 6th. Is this when the phrase grossly negligent was changed to extremely careless?
Sir, again, I don't recall specifically when it happened. I am aware as well of that metadata. My recollection is of working on the draft with a group of us in my office, because it was the largest office, and taking the inputs of probably five different people.
Was it your computer that put the change into the statement?
Based on my subsequent review of that metadata, I believe that to be true.
Okay, and who has access to your computer? Anybody beside you?
No, I do. My secretary had access to elements of it, but
and why was the change made? You were in the meeting where it was agreed that the change would be made. Why was that?
My recollection, sir, again, was, and I'm not an attorney, my recollection was that attorneys within the FBI had raised the concern that the use of gross negligence triggered a very specific legal meaning. In a legal context,
criminal.
In a legal,
criminal.
That's exactly right. In a legal context, grossly negligent is used in various statutes to, particularly one of the mishandling statutes in 793, to talk about a criminal element of the criminal offense.
Okay.
And so, sir, if I may quickly, and I promise I'll.
Well, this change was Hillary's get out of jail free card, right?
Absolutely not, sir.
Well, Hillary hasn't been prosecuted, so if she wasn't grossly negligent but was extremely careless, then there's no criminal standard involved. With grossly negligent, there is.
Sir, I think there are a lot of things I would disagree with in that assertion. First is, she received no get out of jail free card. We pursued the facts.
She did get a get out of the White House free card when the voters cast their votes.
Sir, I've heard that said a lot, and I can tell you there's nothing further from the truth.
Oh,
there was an effort.
Trump won. That's the truth.
So, sir, what I would tell you with regard to that decision, there was concern within the perspective of a legal definition of that term that people would draw an inference based on that use that it was necessarily talking about a particular subset of a statute. My understanding
My time is just about up. That reads 4 Pinocchios. I yield back.
Sir, Mr. Chairman, may I respond?
Gentleman may respond.
Sir, what I would tell you with regard to that decision is that there was concern about the use of the word grossly negligent, and the question of whether or not Director Comey wanted to convey that in the sense of applying the elements of a crime, and that whether or not his use, when people heard that, particularly when lawyers looked at it, whether or not they would interpret that as his saying that she did or did not commit any particular statute. My recollection is that the lawyers, based on that, looking at the use of the word grossly negligent, looking at the way that's been defined, looking at the statute where it occurs, both realized that that was probably not what he wanted to say, and ultimately he made the decision to change that wording and convey what it was he did want to say, and that all of those discussions were generated based on a legal discussion of the use of that term as a legal definition, not as a indicia of violation of any particular statute at all.
The chair recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Strzok. I think it would be